Welcome to today's Mannheim Competition Policy Forum. We're very happy to have James Hodge with us. I think you have many positions in a way, or many things to do at the South African Competition Commission, or the Competition Commission of South Africa, I think how it is called. So you're chief economist, you're also acting deputy commissioner, and you're the chair of the online platforms market inquiry. So a lot of work. Then particular thanks that you managed to take some time off and spend the time with us. Well, prior to your work at the Competition Commission, you were in economics consulting for a number of years, if I'm not mistaken. This was Genesis Analytics, and you also had some time in academia, working at the University of Cape Town. So all the important angles it takes to address competition policy issues. You're going to talk about legal and liability standards in developing countries. Thanks again for being here, and the floor is yours.
Thank you, Martin. And as we discussed earlier, I'm happy to be interrupted. I may not see hands, given I've got the screen and the presentation, but please feel free.
I will manage that.
All right, great. And maybe just before we start, because I think there's a lot of sort of nomenclature issues around legal liability standards. So let me just explain what I mean. And it comes from some of the sort of discussions people like Giannis has had in Cressy and the session we had there. But legal standard we're using just to do the sort of level of requirement from per se through to full rule of reason and anywhere in between, but also where the onus lies within that legal standard. The liability is, in a sense, the economic benchmark for a contravention, whether it be a substantial prevention and lessening of competition, consumer welfare, but also others, such as an adverse effect on competition or a public interest welfare standard. So that's the sort of context. I think maybe just to give you some context to the discussion today and our thinking, or my thinking, and I probably should premise that this is me in my personal capacity. I think there has been a fair bit of debate about developing countries and whether different standards should apply. And I suppose the flag bearer for public interest has been South Africa, but there has also been a debate about whether it should change for other parts of a Competition Act, abuse of dominance, etc. I think now we enter into a world where globally there's this discussion, partly on a public interest, but also on a digital market basis. So whether we need different legal or liability standards for that. I think where the South African context is interesting is because we've had public interest for 20 odd years, and because we've recently amended our act to change some of the legal and liability standards, we have, in a sense, a working natural experiment that one can see how some of these may play out, for good or bad. But in terms of the theoretical debates or academic debates, this is a good benchmark. And I think, Martin, you mentioned earlier, I think other countries bring other things to this debate too. And I think what's interesting is the FTC's policy statement last week on sort of unfair methods of competition and resurrecting part of the FTC Act sort of starts to dovetail with some of the things that we are thinking about too and what we're changing. So let me just start with the South African context. We recently did a concentration tracker report which tried to look at trends over time, but in essence we looked at ultimately 178 markets, but 144 we had enough data to give a trend, and 70% were found to be highly concentrated by your standard measures. And of that, 40% of that 70%, or sorry, 40% out of the 100 was found to have a presumptively dominant firm. So you have a highly concentrated economy. I mean, as we launched the Competition Act in 1998, we kind of drew from probably Canada and a lot of the precedent coming out of the EU. So we didn't use the principled wording in your Article 101, 102. We almost took the precedent and added a lot more detail to our legislation. But in essence, it was to borrow the standard apart from public interest. So we didn't include the by object or effect in terms of cartel conduct and horizontal arrangements. We just listed certain hardcore things like price fixing, bid rigging, market allocation as per se, and then rule of reason for everything else. The liability standard was the same. Our act is littered with SPLC standards, and the underlying consumer welfare standard sits behind that. But that's for all parts of the act. The one exception was in merger control. So there was a realization that in order for competition law to gain acceptance under the new government and amongst the public, it would have to start to redress some of the historical problems in the South African economy. So exclusion from the economy by historically disadvantaged persons, that's the HDP acronym you see there, but also SMEs. The apartheid economy was in essence one designed to withstand sanctions, and so there was a lot of strategic interaction between government and business, a partnership to almost import substitute and support. So many, in a sense, public sanction cartels in many areas. So what I want to sketch out today is just...
So may I just ask a question?
Yes, please.
Because I mean, including those public interest considerations, so it may be a one-way street, meaning that merger control may become more lenient, but actually it could go the opposite way. So what is kind of your feeling overall? How did these public interest considerations influence the decision? Did it on average go for a more lenient merger control, actually to the opposite?
Well, I'll come to that. I think it may be the next slide.
Oh, sorry for that. Okay.
No, it's fine. But I mean, you'll see this is where the design issues come in. And what I want to try and bring through in some of this is, you know, the next stage, if you are going to start to bring in either public interest or other liability standards or legal standards, there's a question about where does it find application? So we started with merger control. You'll see the amendments moved into abuse, but it didn't drag all of the public interest into abuse, dragged only certain aspects. So the design elements are actually incredibly important for how these work out. But let me jump ahead. I think what I wanted to emphasize was these legal liability standards on conduct have not been successful in the first 20 years, and that's why we made amendments. And we didn't tinker with everything, but we tinkered with some things. And we're getting the experience in the last few years, literally last 2-3 years of how that maybe has made a difference. I think one institutional thing that's important to highlight is we have a separation. The Competition Commission is your prosecutorial body, your competition tribunal adjudicates, and you have a specialist appeal court and ultimately a constitutional court, as we're a constitutional democracy. And I think that is an important element because, as you'll see, as we move into some of the new liability standards, you know, it's getting clarity at a court stage. And I think if it's a body that must adjudicate itself and only be subject to review, I think there are some difficulties with how you may structure this. But let's jump in then on public interest, Martin. And maybe one of the key elements of our Public Interest Act and how it was set up in merger control is you've almost got two elements up there, and I'm referencing the Act as you can go and look at it, but I won't show it to you now. But the first aspect is you might have your classic. If you have an SPLC or you find an SPLC, then you want to see if it can be justified on efficiency grounds that might offset. And in addition to that in our Act is public interest. So there's almost a sense here of could a positive public interest trump a negative competition? Now, to answer one of your questions, that has never been found. So ultimately, it hasn't resulted in a more lenient merger control regime because public interest has not been found to trump. And that's partly because of the second element, which is not only if we find an SPLC must we assess this, but independently, the courts must assess if the merger itself can be justified in public interest. So there's almost a standalone public interest element. And why this is important is, I think what the complexity that's always envisaged with this inclusion of public interest is, how do I weigh it up? How do I weigh up a degree of inequity or loss of employment to potentially competitive benefits that may sit there, or efficiencies? And the two may be flip sides of the same coin. In fact, a merger that thins out the workforce and avoids duplication might create efficiencies and cost benefits. And so, how resolving those has always been typically considered the main problem. What we did by separating ultimately, and now whether that's clever design or ultimately how the courts have sought to disentangle this is as I like to think of it as an economist, we've almost got a welfare standard for a particular class of consumer or group or industry or region. So we will say if employment is harmed, that's a public interest harm. So there's not a weighing up at all. We determine there's a public interest harm. And because in merger control, you can actually bring in remedial action and conditions. What has been the practice generally is to remedy the public interest effect. And so in a sense, I've also called this a sort of welfare redistribution. If the merger can only go ahead because you take from employees to give benefits to shareholders, well, then mergers won't go ahead. But if the gains from a merger are broader and you can address the welfare of the employees and leave them neutral, then the merger can go ahead. And I think that's a critical element of the design, because it is inherently difficult to weigh up, say, the development or impact on a region or SMEs or employment against certain efficiencies. I mean, what we've seen in things like region and economic development is that maybe a merger that looks to consolidate production facilities and move out of poorer regions to consolidate in wealthier ones might be considered an impact on that region. You may consider then remedies that look to sustain that production facility in that area, and there may be other efficiencies that certainly can go ahead. So I think that's the way we've approached it. Yeah.
May I ask how this is implemented then concretely? So for what is the time horizon then as a condition typically put in place? Is it, say, how many years is then their commitment that certain production facilities will be maintained, for example?
So to give you some idea, I think the first case was on employment. This was the Harmony Goldfields case. And what we'd seen is that mergers amongst mining companies had tended to result in large-scale layoffs. And there is economic theory around this, that this sort of labor contract between unions and management is broken with a merger. And so it creates the ability to then also restructure at the same time. And the precedent coming out of that was there were 1,500 jobs at risk. These are people who, given their grade in education in the South African context with 40% unemployment, are unlikely to find employment. Skilled labor is likely to find, so we don't worry about that. So employees below a certain grade, there would be no layoffs for a number of years. And it's evolved from no merger-specific layoffs for 2 years to 3 years to 5 years. We've also had more recently conditions, which is the headcount must not change. So some of the global mergers, so AB InBev, SAB Miller, for instance, where AB InBev has quite a, in some respects, notoriety for being highly efficient and driving big efficiencies through, those sort of conditions get put on. On supply development, they may also have a period or a fund. Sometimes with supply development, it's been a fund. In the Walmart case, the concern was that because Walmart has a well-developed strategy around sourcing from China, and this was at the time sort of 12 years ago, with warehouses in China, big facilities for that supply would move offshore away from local suppliers once the merger happened. And so there was a fund of 250 million to support the development of local suppliers. So it allowed some efficiencies by certain things could be offshore, but you need to put in money to develop. And that has been one of those success stories where Walmart ended up, even some of those suppliers have supplied them globally, and they've been a bit of a champion for some of this. It's not always worked, but I think it is a sort of temporary in the sense that people may be retrained, find other employment, and move on, and it may be too much to permanently hobble this. So I don't know if that helps with your question, Martin. I mean, maybe on the conduct side, look, cartels, we were early implementers of the corporate leniency program. And with the per se standard, this has not been an issue for us. Cartels has been a big success story in South Africa. And maybe because of the amount of cartels in the country, it's been a steady flow of cases. I think that's changing now as the big cartels have probably have been uncovered, but there will still be issues out there. The issue has been on abusive dominance. Now, as I recorded, we have a highly concentrated industry, but if you look at our record up until the amendments, over 20 years, effectively 8 cases confirmed by a tribunal and an appeal court. So there were others, one at the tribunal, but lost at an appeal court. And the same with sort of interim relief. Now, I don't know how that stacks up globally, but certainly I think the problem, as I point out in the slide, is that one of the difficulties is just the sheer length of time to bring these cases to successful conclusion, even where there is guilt. And some of the challenges, and I just want to highlight here ones that are not about, in a sense, structure, because why I wanted to avoid the structure debate is the way that debate has moved is developing countries have a more concentrated economy, a small economy, and therefore certain conduct, such as vertical practices or restraints, are more likely to harm. But where that debate leads us is almost to a presumptive standard, where certain conduct is presumptively a contravention, unless otherwise exempt or the like. And the direction we've taken in South Africa is not that presumptive standard. There are many jurisdictions on the continent, African continent, where that is the case, where there's almost a per se prohibition of vertical restraints unless there's an exemption granted. But we haven't taken that route. I think some of the challenges where we have seen is, I mean, typically any authority faces an information asymmetry. And the way our courts interpreted the full rule of reason approach was to say, well, whilst the respondent may have some onus to show that there are efficiencies that offset the effect, you, as a result, need to fully quantify the effect in order for that weighing up to happen. So an enormous burden on demonstrating effect from the conduct, which has maybe exacerbated, given a lot of information sits with the company. I think the other thing we face, which I'd be interested to hear how Germany fares, but is jurisdiction. We are a small developing country. For many companies, they will tell us we are .whatever% of their global turnover, and the documents are all sitting in Zurich or Mountain View, California. And so access to documents has proved a major challenge. We've had a recent case that was referred where we were told by a pharmaceutical company to approach the head office. We did. 6 months later, they came back and said, no, you must go through diplomatic channels. We went through diplomatic channels, South African international relations to that country's international relations, to their competition authority, only to be told, there's no mechanism for sharing of jurisdiction, and therefore we can't be helped. So 2 years of wasted time just to get nothing. The other, and this is a term I know some of the economists have sort of framed, called signal jamming, which is almost an obstructionist tactic, which is to say, well, the cause of the problems for some of the complainants is not our conduct, is potentially other things. You haven't ruled those out. Therefore, your analysis is incomplete. Or there's these theoretical efficiencies you haven't assessed or weighed up. Of course, we sit with the information and we're not giving that to you, but without you having assessed that, it's an incomplete. And so sometimes this finds favor with the courts, but is a problem if you don't have a point in the process where the onus shifts. And that's where I'll come to, where our amendments have begun. I think a third area is many of the cases, price discrimination, even inducement not to deal. We've got a few where the complainants being SMEs, the question on the SPLC standard is, well, there are some rulings which even say we can see the harm to the complainant, but it's not clear there's harm to the process of competition given the complainant's size and insignificance. And that's quite an important thing. And just that last point on the slide is, I think what our perspective almost, SMEs can be seen as a public interest in our act, but we like to see it as, yes, public interest, but also competition. That South Africa has a very small ecosystem of SMEs. I think our recent concentration report identified that they account for roughly 25% of value add in South Africa, but in the OECD, the average is 50 to 60%. So unusually small in South Africa, but that is your future competitors. And we think a healthy ecosystem is healthy competition, but that is a long-term dynamic effect. And we all know competition law is not good at long-term dynamic assessments because courts don't like that, it becomes too uncertain. So
I think there has been quite some debate on the role of SMEs in countries such as South Africa. And I guess some people are saying it's, well, we can talk about competition policy, but the real problems are somewhere else. It's much more limited funding. So it's much more the problems in the financial sector, which possibly explain this. And I guess the second element is maybe in some countries, I'm not sure about South Africa, may also be a measurement issue because many of those companies are operating in a, say, semi-formal sector or even in the informal sector. That means part of those activities are not properly accounted for. But I take your point just as two qualifications, I guess, about the role of SMEs. Now, what I wanted to ask you, I'm not sure whether that's coming in subsequent slides. Is there any, in practice, any role for private enforcement in South Africa?
Yeah, so maybe, Man, let me start with your first one. I mean, this is precisely what gets faced in litigation. You know, this SME is inefficient. This SME has a funding problem. This SME is badly managed. And I think we know that there are many factors that affect, but you know, what is clear in South Africa is entry barriers and barriers to expansion are part of the issue. There is finance, there is, and those may play a different role for different companies. But to take a simple example, I mean, we've had exclusive leases at shopping malls, which account for 50% of shopping trips, which basically have kept out small grocers completely. Now that's a real factor. And once we've removed that, we recently removed that through a market inquiry and settlements. But it's amazing the activity that flows after that. Even sort of specialist store franchisees in butcheries and liquor have suddenly entered and moved in. So just on that, I think it is a combination, and what we see is competition policy must start to be be located within fixing other problems as well. But those other problems can't be fixed without fixing the competition aspect as well. I mean, on private litigation, if the commission chooses, so the complainant must come through the commission. They can apply for interim relief directly if they feel they're being harmed, and that's something that's happened more often recently. But we must come to a decision. Either if we non-refer, they can take it up privately at the court, but it must come through us first. They can't bypass the commission straight to the court. Yeah, so I think, I mean, the last thing is we have a low cost of appeal in South Africa. Anything, appeals are heard. There's not a discretion to not hear them. And typically that is on the papers 1 day or 2 days. And so there's a low cost for big business to just appeal. And that's become a standard route, that almost every decision is appealed if it goes adversely. So I think that, and the fact that the higher courts sometimes don't have the same expertise and don't have the same perspective on competition law has been another challenge, I think. But let me go to some of the amendments, and I'm going to use that category, as I said, of liability and legal. So the idea was to strengthen our ability to prosecute conduct. Excessive price was singled out because the number of what we would say almost super dominant companies, and the concern that their pricing at an upstream level was hindering development of intermediate producers that could grow employment and develop more the downstream beneficiation. So just to pick out three here, and I am premising, as I said, the SMEs as a competition, but also a public interest. But buyer power is a fairness standard. Now, the wording looks similar to that you have at the European level. But I mean, the practice at the European level has been far more around monopsony pricing and monopsony conduct. I suppose the way ours is framed is far closer to, I think Germany and France have this inequity of bargaining power provisions at the national level, and is far more akin to those, and I'll show you through the regulations. So the fairness standard as opposed to an adverse effect in SPLC. On price discrimination, we already have an SPLC standard and offense. So we added a second one, which was around participation. And certainly there is a debate about what does participate mean, but you'll see from the wording here, you had prohibited price discrimination if it's likely to have an SPLC, and then secondly, if it's likely to have the effect of impeding SMEs, HTB firms to participate effectively. And I'll come to it in a couple of slides, but what has happened in all of these is because these are new contraventions in negotiating the amendments to the legislation, business said we need more certainty as to what this means. It's hard for us to comply if we want to, if we don't know what it means, and it would be unfair to fine us on a first offense if you hadn't clarified where you're going with this. So the complement to these has been a requirement. There's a must-have on regulations from the minister, and the commission has sought to put out guidelines as well. In a market inquiry, it's your adverse effect on competition standard. I think this is similar to the CMA. But in essence, we must decide if any feature impedes, restricts, or distorts competition in the relevant market. This is seen more of a pro-competitive measure. Any feature doesn't have to be the conduct of a dominant firm. It can be a feature of a market that has arisen naturally, but which collectively the action may impede competition. So to take an example from one inquiry on banking, no bank really facilitates switching between banks because it's not in their private interest to do so if no one else is doing. That's a feature. You can impose that on everyone to make it happen, to enhance competition. It's not a finding of wrongdoing or fault. It's a finding of a feature that does not work. In terms of the legal standards, the big shift has been this prima facie case, and then I'll talk about inquiry. So on excessive pricing, where the liability standard remained the same, but then on buyer power and price discrimination, which are in terms of SMEs, the shift was to create a prima facie standard. So you almost created a rebuttable case at some early stage where then the onus shifts onto the respondents to prove otherwise. And it's interesting just how it's worded. But I certainly think, you know, and I'll come to it, I think this has helped preserve almost some of that we don't increase the type 1 errors out there whilst removing some of the type 2 errors, because you have a ability to rebut, unlike the presumptive standard, which may limit that rebuttal and arguably could increase the type 1 type errors. So on excessive price, we borrowed a bit from United Brands. And so you'll probably know in United Brands, it was whether the price is above, I mean, they called it economic value. In our law now, it's clarified as the competitive price. And then the second part of that is if that difference is unreasonable. And so in essence, and I'll come to a recent ruling, which fleshes this out, but in essence, on the prima facie case, we would have to show that it's in excess of the competitive price, and the dominant firm must then show why it is reasonable. So they need to rationalize and justify their pricing decision. And that is an important shift I'll come to. It is very much changed the game in a number of cases, and obvious cases. The buyer power it's shown.
May I ask you on this excessive pricing one, because I think there South Africa has been kind of, well, leading, or at least it's not clear whether others are following, but at least there has been some excessive pricing cases. So I haven't, I mean, I do understand the concern perhaps, but then I'm wondering, how do you pick actually the cases? And for example, take Porsche or some of these luxury car brands. And if you look at some of their profit margins, they are really high and consistently high. Could you run an excessive pricing case against a luxury car manufacturer? Look,
you know, you have prosecutorial discretion as to where you want to put your effort. So we do prioritize. And where our priorities tend to be is upstream intermediate inputs that may hamper downstream, and products which maybe exploit low income consumers. We may have less interest in the luxury consumer who is paying. And here is where the rebuttable element comes in. Porsche can come and argue that, in fact, given the innovation, status, scarcity value, that in fact this is warranted, and that some of their research and development and the like warrant that difference. So this is where it is before the court, and they have full ability to rebut the presumption.
I guess the point is less about it. Take away the innovation argument. So this would work possibly to say, well, essentially the value is derived from scarcity. So therefore, I mean, the competitive price actually is not really something we should be thinking about. If you think about, I also say luxury watches, it's really the fact that there's just a limited number of them being put on the market, or that the price is so high that only few people will buy it. So that could be used.
There's no limit to what people were put forward. I'll come to the case which has been, ultimately these were tested under price gouging, where you could argue scarcity, but where the courts found that in fact that was not an argument. And in fact, the justification put up was not a scarcity one. It was one that I anticipated my cost to go up for face masks and sanitizer, but was found wanting when there was no evidence to that effect, to the same extent that the price increases went up. So I think the point, Martin, and we have recently referred, and you can go look, a case against a pharmaceutical company for excessive pricing in a patent period. And naturally, there will be discussions about R&D and other things, but we can have those debates and we can assess it. But that I think is important. Important is at some point the onus must shift. So let Porsche come with its presentation of how they think it should be assessed and whether it's reasonable or not. And let's have that discussion. So,
but this kind of prioritization, which seems to make sense, but is this somewhere in the law, or is this really discretion by the authority?
It's in the practice. So look, as with any authority, if you receive a complaint, you may be obliged to assess it, but you can still decide to non-refer because of prioritization. But it is about where you have scarce resources, you must decide how best to allocate them as an authority. And we think most clearly around where the priorities are for the country and the consumers in our country. So where we initiate ourselves and go look for cases and concerns, that is the kind of things that may be the benchmarks for us.
I just fully understand it, but in a way, since there is all this public interest debate out there, which is then about once you have a case, how to consider public interest, the question is whether to make it a case, to what extent this could be actually helpful to have some kind of public interest consideration mentioned there as well.
Yeah, and let me come to that price gouging, but there was an element of public interest or public welfare in that. So the question in any gouging case situation is, the economist might say, well, that's an important price signal to have the market clear and to balance supply and demand, and then bring in new supply. The approach in South Africa was, no, this enables the wealthy to get health protection in a pandemic and the poor to be left exposed. That's not what we think is fair in the context of a pandemic. And so there should be some rationing involved, and price should not be the rationing mechanism because it has an inherent inequality in it. Whether you agree with that or not, that's the approach that we took and the courts also took in this case. So this is where the debates can happen. I'll come to, and what's interesting is what I haven't put in the presentation, which is a more recent development, is that a recent case in healthcare went to the Constitutional Court. And as a constitutional state, we must read the Constitution into all law. And so there's now, through that case, a precedent that's saying, look, it's not just dealt with through public interest, because you have a public interest element of competition law. Actually, how you consider substantiality, for instance, in a substantial prevention or lessening, has a constitutional frame. If this is a basic right or product or good or service that is part of a basic right, then you can't say, well, because there's a minimal number of consumers that are impacted, that it's not substantial. It's a right. So you must read the Constitution into that. And that is going to shape our law going forward. I mean, we've seen now in a number of interim relief applications, the issue of exclusion of historically disadvantaged individuals. So actions by dominant firms that do exclude someone, but their status as historically disadvantaged now has a constitutional element and exclusion from the economy. And that is going to be an important read over, I think, for our Act in the years to come. But this is where, as you say, moving into some of these, the assessment could be, well, Porsche is just a luxury good. We don't really concern ourselves with that, and there isn't the strong angle. But certainly as an authority, how we prioritize is informed by where the impact will be, I mean, we've got there, you can see the prima facie case for buyer power and price discrimination premised on the way it's framed as a liability standard. Interestingly, on market inquiries, there is no express weighing up of efficiencies. The Act reads as, you have to decide if there's an adverse effect on competition. And that's it. There's no requirement to look for justifications, efficiencies, or anything. The only area where it may come through is when you seek to remedy that, do you factor in the proportionality and the extent? But I mean, I think what's interesting is, again, that FTC policy statement last week precisely says in some cases we may consider the justification, but in other cases we may not elect to. And certainly we may consider, if it's a private justification and gain, to not consider it because we're looking at the public. And so I think there is these developments that are happening that are bringing different angles on competition law and how we think about it that are interesting to just explore. I mean, maybe the last thing, and I'm just wary of time as well, but we did have, I mentioned the regulations, and regulations are not binding because the minister cannot alter the law. That's the job of the legislature. But it does provide, in a sense, guidance that these become factors which almost you must or should look at where they are relevant, which at least the exercise goes through that element. There were regulations on price gouging, which looked at whether the price increase corresponds to the increase in cost, or the flips, the equivalent, which is do your margins increase. And in some respects, that's even contained in some of the European Commission excessive pricing discussions. I think it was even in United Brands, an obvious situation may be, well, with price goes up and cost doesn't, do we think there's more of a abuse here? So that was in terms of gouging. But if we look at buyer power and price discrimination, and I haven't tried to replicate them all here, on the fairness standard, in terms of SMEs, the one element is your price level unfair? And there, the regulations looked at whether you pay a lower price to SMEs compared to large suppliers for the same product. There's obviously a question on like good or services. It's maybe easier in a commoditized world than a non, but that is one of the standards. And then there was a standard around whether you reduce price, so that unequal bargaining power, which was used to push price down, and whether that is retrospective, unilateral, or unreasonable. So that is often where it finds expression, that a powerful buyer says, well, actually, I'm not paying you as much, I'm going to push your price down. And this is exactly the cases we've faced so far. I'll come to. On trading conditions, I mean, interestingly, we've also borrowed from European Commission regulations, much like we borrowed on price gouging from US state laws on gouging. But if you think of your food value chain regulations, and the buyer power between retailers and the smaller produce suppliers, there's this idea of unreasonable transfer of risks or costs, one-sided, onerous or not proportionate, unrelated to the object of the clause. But those are things that courts can tackle with as a principle. It gives guidance. You can produce evidence to that effect, rather than being more prescriptive. So often regulations are principle-based, not detail. The detail should be in a guideline, not in a regulation. On price discrimination, there's the normal things on how big is the differential, etc., whether there's any cost but justification. But here it was far more around, again, effective participation is has that differential limited the demand for the small business or their investment in the product, and this, we will see how it plays out, and whether that becomes a useful standard or not. I'm just going to give you three examples and then conclude. But on excessive pricing, I mentioned.
May I, before you get to those examples,
yeah.
could you go back perhaps to the previous
sure.
slide? So I guess the last point, the price discrimination element, you could really link that mostly to raising rivals' cost. So that would be kind of very traditional way of thinking in competition economics. Like some of your the abstract example you provided on on a fairness standard on pricing in relation to buyer power, I think even there also you would be able to use that argument of raising rivals' costs. So I'm wondering, where do you think do those provisions step away from our standard economic reasoning? So in some cases, it maybe just makes things more concrete and therefore make your life easier at the court. And I think that's a good way to go. And I'm wondering, is there something else in there? Are there kind of arguments which can be used, which in the end do not boil down to increased barriers to entry or raising rivals' costs?
Well, look, on a buyer power, the one approach a firm will typically take is to say, well, we pass this on to consumers. Therefore, on the consumer welfare standard, there's a benefit, and you should allow scope for negotiation. By introducing a fairness standard, we're saying, much like in our merger control, we are just looking at the fairness for this class of supplier, SMEs or historically disadvantaged. So we are deliberately not looking at whether it's offset elsewhere. And so the typical economic framework would start to look at that broader frame. So that's why by narrowing it and not saying we're weighing up or we're looking at consumers on the flip side, and many retailers may well pass some of this on, but we're saying there's an unfairness, it harms a group, and we must address that harm. And we as a policy have said that is in the public interest ultimately. Consumers may then not get exactly that same benefit, but in the long run, we think this is balancing the interests within society. And you know, before I spent time as a competition economist, I was a trade economist. And so one's not unfamiliar with offsetting consumer and producer interests in a trade environment. Tariffs obviously harm consumers, but they may benefit producers and benefit economic development. So these, you could say, are better as policy decisions than court decisions. And that's why you frame it deliberately in the legislation in a way that does not let the court try and do that weighing up. So I suppose that's where it stands. On the price discrimination, it is not to capture the vertically integrated raising rival cost that the SPLC is there for. This is to capture the simple bargaining dynamics where, you know, large buyers negotiate good discounts and I look to extract what I can basically out of small business. And I look at their sort of maximum willingness to pay. And so that you can say that it has a competition effect downstream, but given they're small and they may not be the price setters in the market, you get that SPLC problem. So there was a definite case called Nationwide Polls, which created this issue around how we look at price discrimination that led to this amendment. So the participation, you know, we'll see whether there's wisdom in the use of that word, but this is almost saying, well, I may not show that prices would be different out there, but can I show that this class of SMEs, for instance, because of the discrimination, are smaller as a result? They're less profitable and therefore don't make the investments, or they have less demand. And to take simple examples in the world of retail, you know, large retail stores may get certain products at a deep rebate, and they put it on shelf at a price that's lower than the cost to supply a small independent retailer. And so for some of those products, independent retailers no longer stock them or stock them in much regard because they can't compete in that sense. And so it's stifling the size of their business and their investment. And so that's where these sort of come into focus. Even in the online world, we had provisional findings around whether the different pricing commissions in food delivery to small restaurants versus national or international restaurants affects their ultimate pricing on the menu and ultimately the demand for their products, you know, or restaurants. So I won't dwell much on this. It's more the Babelechi at the appeal court. This is some of the excerpts, but the first one is just to show that almost once we established dominance, the inquiry follows, we must show that the price charge was excessive. They cite certain evidence that we had the pricing and margins prior to the pandemic, how those increased, how their costs didn't increase, how they couldn't put up an innovation rationale. And so the prima facie case was established, and then there's an evidentiary burden shift. And here, as they say under paragraph 59, here the appellant must prove a justification for their price. And what they set out then, and it's a few paragraphs, I've just chosen a shorter bit, but in essence, that they had set out that they expected cost to increase given the scarcity, but all the evidence around expectation of cost increases were in line with either a slight depreciation in the South African rand or maybe a doubling of costs, but they had put up prices by 888%. And so the court found that the evidence they adduced is unconvincing to justify their price increases, and hence the excessiveness. Hence, it's not reasonable. What was important here is that it forced, and here the appellant is the respondent in the tribunal case because they appealed a prosecution. But it forced that firm to justify its pricing. And in a sense, in the court and in the court of public interest, that was assessed. They had to put in the rationale. Why did I increase it by 888%, not 100% or 50%? And this is where they found wanting. And I think that has proved important. I mean, outside of price gouging even, there are referrals that play now which go to exactly, justify why it is so much higher and account for that. And if you can, all fine and well, but if you can't, then we're setting some threshold or benchmark for how you may be acting. But in essence, you're saying to firms out there, you're going to have to justify your actions. So behave in a manner that is justifiable, not in a manner that isn't. And that, I think, is what changes with this prima facie case standard. And as I indicated, I think the cases that came, and price gouging has its own debates, but I mean, the cases that came and were decided, you wouldn't say were a type 1 error. If they were let through, it would have been a type 2 error. On buyer power, I mean, what is interesting is these were not cases that
one thing I would like to know is to what extent can I use really this cost argument? If I can use just opportunity cost, and if there is limited supply, I can say, look, I could have sold it to somebody else for the same price. So therefore, my opportunity cost of selling it to you was what I could have made somewhere else, which is different in the case where it would have been feasible to increase supply, but due to market power considerations, I did not. So therefore, I'm wondering whether you will be able to separate those, because if there is scarcity, then even if I'm a very small player, I can have very high margins.
Exactly, and I mean, that's the whole point, Martin, is within a rebuttable case, any argument can be put forward to justify, is then to be assessed by the court and to be argued. And in that context, it may be that certain courts or jurisdictions may accept the opportunity cost argument. Ours didn't. Ours said in the context, price should not be the allocative principle. And even the way we approach price gouging is we never brought cases against really manufacturers per se. Retailers and resellers are not even if you took this sort of theory, are not the ones who need the price signal to increase supply. It's the manufacturer. So if the manufacturers, start increasing price and expanding output, we may leave that alone. A reseller is just opportunistic. But maybe on buyer power, and I think this is also an interesting one, this happened in the dairy industry, and farmers were told at one day's notice, we're going to impose a levy on you because we now have costs in terms of COVID, PPE. We've got uncertainty as to how product demand may shift because of stockpiling or not, and lockdowns. And in essence, the approach we took here is we wrote them a letter saying there is a prima facie case of abuse of buyer power. And in essence, if you don't retract your letters to farmers and change your course of action, we will prosecute you. And we set out to those dairies how, under the regulations and the new legislation, they were in contravention. So this is where the regulations do come in use, is dominance is in essence, often these are localized markets, processes, fresh milk is supplied to a certain radius. But all of these actions were completely unilateral. There was no engagement at all. And it was unreasonable in the sense of they were speculating as to how they may be affected. And even if they were affected, so were farmers by these things. So there's an unreasonableness about, I can protect myself because of my position by pushing all my costs onto you. And I'm left neutral by a pandemic when the entire value chain is harmed otherwise. These were immediately retracted. And that's where I think the strength of reasoning that there's a realization this is unfair. It is high risk. They were all advised by big law firms. And some of it led to interesting action. So one of them, in fact, then said, we are putting this on hold for a month. They, a week later, held engagements with farmers. So then there's engagement, not unilateral. They sought to do that. They then decided to halve it. But as the speculation gave way to a realization that, in fact, because food is essential and people are still going to eat, and that value chain still operates even in a lockdown, they weren't affected badly on profit. They dropped it altogether. So one went the sort of route of, well, I'll engage how you've set it out for me and look at unilateral and unreasonable. And that led to a change in behavior. Others just realized that it was. So there's always a question with buyer power that, do you get complaints because people don't want to complain against the person buying their products and whom they're dependent? But there are some instances where it happens. So I think this was an interesting one. On market inquiries, and I'm flagging here digital markets because I'm going to just bring in, and I'll be brief now because I see we've almost out of time, but in essence, there has been, of course, this debate with Europe going the regulatory approach on digital markets. There's been reports that have suggested a presumptive standard. A market inquiry, which we have, and now we have with powers to actually determine remedial action. Previously, we had it, but only the ability to make recommendations and no decision-making powers, you could say. Why this is interesting, I think, even for digital markets, and our first inquiry has been digital markets, is that the lower standard of an adverse effect on competition and also looking at a broader factors means you can tackle a broader range of issues that are facilitating, even things like network effects or market features. How they play out and affect competition may mean you could put in remedial action. I mean, we have looked at, and this may be also part of our broader mandate, but how do the ability of South African platforms to compete with global platforms, for business users to compete against each other, not just in a self-preferencing world, but genuinely between each other, large restaurants versus independent. The other value, I think, is you get to look at an ecosystem or value chain. It's not about the single conduct of a single firm. And you get to look at potentially how you fix that ecosystem, because you could fix one part and it doesn't make any difference. And this, I think, does have relevance to the digital market environment, especially, but it has a lot of relevance to other traditional economies where your value chain you want to assess. And to your earlier point, Martin, you know, if SMEs, there's various things that you want to sort out, financing along with barriers, etc. But I mean, interestingly, we've looked at the role of general search, the role of Google search in platform competition. Where you appear on Google affects your traffic. how paid search works on Google, who gets the bulk lion's share of that, etc. Is that influencing platform competition? We can look at that and look at conduct of platforms that are potentially dominant. So there's this potential for a holistic set of remedies. And I think the other is the stakeholders, that you have powers to require information from a broader set. And in a conduct case, you may have direct powers, obviously, on the respondent, but how much you can get from others is up to their goodwill, and you may seek to summons, where that's never a good outcome. But it's also public hearings, getting broader stakeholder base about interests. So I think an inquiry is an interesting tool, and it's not just the legal and liability standards involved. It's that process of looking at an ecosystem and a broader stakeholder engagement. You do have to have provisional findings, recommendations. You do have to consult on that, and you do have to consider the submissions in respect to those. So there's the normal, in a sense, checks and balances, and decisions can be appealed. So there's the ordinary court appeal process. But it's an interesting process we'll see moving forward. I mean, our current inquiry I can't talk about because we haven't concluded yet, but we should be done by 18th of March, and then we can have that discussion in more detail. But I think in the debates around market inquiry, in the debates about digital markets, this is an interesting tool that may differ. And you may not have it in Europe, and it may be now the FTC is trying to use the unfair methods of competition to come into this space in the same way. But it's, I think, raises this just broadening of toolkits. So there's legal liability standards, but there's also toolkits that you have at your disposal as an authority to address. But maybe just to conclude, I think this is a time where there is a lot of debate. And I think what I'm hoping through this, at least, policy forum is give you some insights to a country which has different standards, but has also changed them recently, and how that seems to be working. But it provides at least a working model that can assess how some of these changes may or may not influence, and whether they're a good thing or not. Because I think what I've seen often is the debate, certainly around public interest, is almost what issues must come in, but sometimes not as much thought into where they find the application. Is it only in merger control? Is it only in exemptions? So is climate change an exemption thing? Cooperation to improve technologies or reduce emissions that you wouldn't have otherwise? Or does it find application in mergers? As I said, we have a broader set of public interest in merger control. In abuse, it's only SMEs, HPs, because we think that links to competition and market structure issues. And then what is your standard for legal liability? Do you weigh up and still have a consumer welfare standard, or do you have a narrow welfare standard around that particular issue? Do you have a rebuttable case that shifts the onus? Do you have a presumptive standard? But I think our current experience suggests that there may be some value in this rebuttable case in terms of decision-making. It at least is not a presumptive, which may have bigger risks of type 1 errors, certainly as you get into certain categories. But yeah, I think let me end there and stop sharing and see if there's any other questions, discussion.
Well, probably our audience today is shy, so what I suggest is that we thank you now officially and end the recording.